One of the core principles in our system is that everybody is equal under the law, and nobody is above the law, and nobody is above the law. No, and nobody is above the law. I think it's important that we discuss all of these cases.
Nobody is above the law. A very clear and obvious statement. In the UK, according to the Constitution, every person and public body is subject to the rule of law, except for the King, who technically has sovereign immunity, but that's a topic for another day. If a crime's been committed, the CPS deploy a two-stage test. 1, is there enough evidence for a realistic prospect of conviction? And 2, is it in the public interest to prosecute? Because the issue lies with the public perception of how this is applied. So what we're going to do is go through 3 controversial cases demonstrating how this was applied in real-world scenarios. Hello, my name's Ryan, I'm the co-legal lawyer, and I give a legal view on the latest news. Okay, so the first stage. Is the evidence strong, reliable, and admissible so as to likely result in a conviction by a court or jury? Second stage. What is the public interest? Well, this doesn't have a fixed legal definition, but instead refers to matters affecting the security, safety, and welfare of the public, as opposed to private or personal interests. The CPS state that they consider things like the seriousness of the offence, the harm caused to the victim, the impact on communities, and the age and maturity of the suspect at the time of the offence. By having such a wide definition, it allows its use to be flexible, but this is a gift and a curse, because the perception from the public, or the allegation that has been put forward, is that it's been used as a get-out clause, where perhaps the CPS have been subjected to external pressure, especially where the suspect is powerful or high profile. Okay, the first case. In January 2019, Prince Philip drove his Land Rover off his driveway onto the A149 and caused a collision with an oncoming vehicle, causing injury to the occupants. The highway code's clear. You've got to give way at junctions. So he could have been charged with careless or dangerous driving. In the end, however, the CPS decided not to prosecute. Chris Long, the chief Crown Prosecutor, stated, "We took into account all of the circumstances in this case, including the level of culpability, the age of the driver, and the surrender of the driving licence. We've decided it would not be in the public interest to prosecute." So, with culpability, we've got 4 factors. Of those, it's safe to say he was negligent, but there's no chance it was deliberate. He's 97 years old, and the courts have historically dealt with elderly drivers with more leniency. And finally, he gave up his driving licence, which meant that a driving ban would have been completely pointless. So I think it's safe to say that, high profile or not, avoiding a costly and public prosecution was the sensible decision. Our second case involves Dominic Cummings, the senior advisor to Boris Johnson, the Prime Minister at the time. In March 2020, Mr. Cummings decided to drive from his home in London 260 miles across the country to a farm in northeast England. He also possibly had coronavirus at the time, and to top it off, he drove a further 60 miles to test his eyesight. Now, this was during the pandemic when there were severe restrictions in place. In fact, Regulation 6 of the coronavirus regulations stated, "No person could leave the place where they are living without reasonable excuse." Durham Constabulary, investigating in their press release dated 28th of May, stated, "There may have been a minor breach that would have warranted intervention, but it was considered minor due to no apparent breach of social distancing." Now, this is an unprecedented time where our freedoms are being restricted, people are being prosecuted across the country with over 20,000 convictions, and Dominic Cummings was actually pushing for higher fines for breach of the regulations. So you can understand the public sentiment over Durham Constabulary's decision was one of outrage, because for someone pushing for higher fines in these strange times, shouldn't he be held fully accountable to instill public confidence in these emergency measures? Our third and final case involves the late Labour peer, Lord Grenville Janner. who was the subject of allegations of abuse in the 1970s and 80s. This case is mired in controversy. In April 2015, the CPS concluded they would not be prosecuting Lord Janner because he suffered from dementia, which was incurable, and that he was therefore not fit to stand trial. He also posed no current or future risk of offending. That upset a lot of people. Just 2.5 months later, however, that decision was overturned, and it was decided that it was in the public interest to prosecute Lord Janner. An assessment was made to see if he could stand trial, and it was concluded he wasn't fit to stand trial, but that there would be a trial of fact. Unfortunately, however, in late December 2015, Lord Janner passed away, and that trial never took place. In January 2016, a report was published which concluded there had been sufficient evidence to prosecute Lord Janner on a number of occasions, being 1991, 2002, and 2007. As such, a high-profile individual, due to multiple failings from the CPS, evaded trial. So with all of that in mind, it's going to be very interesting to see how the current situation plays out with Andrew Mountbatten-Windsor, who's been arrested on suspicion of misconduct in a public office, sharing confidential information with Jeffrey Epstein. We don't have the information available to the police, who are conducting searches, but if past history is anything to go by, let's just hope it's not controversial. Anyways, like, share, subscribe, leave a comment or question, and check out our website. Thanks for watching.